All rise.
The Kosovo Specialist Chambers is now in session.
Good morning. Welcome, everyone. Before we start, we'll give an opportunity to the photographers. I'm sorry. Oh, you may take your pictures. Thank you. In my capacity as presiding judge of Trial Panel 2 and pursuant to Rule 124 Sub 1 of the rules, I hereby open this trial and ask Madam Court Officer to call the case. Please tell me about what subject?
There is still an outstanding motion under Rule 1172, presumption of which being that motion will be determined prior to the opening of the case under the rules.
The interpreters kindly ask the speaker to speak into the microphone. Thank you.
Which specific application? For what purpose?
Application, a motion to exclude evidence.
Interpreters' apologies, we do not hear the counsel. By Monday the 4th of October.
Is the interpreter getting the feed now?
No, Your Honor, we can't hear him.
I'm sorry, Mr. Reese, they cannot hear you.
Well, the mic is on, Your Honor.
Okay.
Now using the other microphone, does that assist?
Yes.
The issue apparently is it's actually can't hear the interpreter.
Will the interpreter please say a test phrase in Albanian so Mr. Haradinaj can see if his mic or his earphones are working? Is it working? Okay, thank you. Mr. Rees, I understood your point made that the 117.2 application that you had made to exclude prosecution witnesses has not been ruled on. I rule on it now orally. We have deliberated on the matter. It is overruled, and a written reasoning will follow. So now I would like to ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office.
Good morning, Your Honors.
Oh, you didn't? Oh, I'm sorry. I'm sorry. We stopped before the court officer could call the case, so go ahead, Madam Court Officer.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Haradinaj.
Thank you. Now, Madam Prosecutor.
Thank you, Your Honors. Good morning. For the Specialist Prosecutor's Office appear today Jack Smith, Specialist Prosecutor, James Patch, Associate Prosecutor, Matthew Halling, Associate Prosecutor, Line Pedersen, Case and Evidence Manager, and I am Valeria Bolici, Prosecutor with the SPO.
Thank you. And now I turn to the defense. Mr. Rees, please.
My name is Jonathan Rees. I appear on behalf of Mr. Gucati. I'm assisted by Mr. Hugh Bowden, Miss Eleanor Stevenson, Mr. Remy Halilai, Miss Faye Wigmore, and Mr. Joseph Bowden.
Thank you, Mr. Rees. Mr. Cadman, please.
Good morning, Your Honours. Toby Cadman, Specialist Counsel for Mr. Haradinaj, who is present in the court today. Beside me, Mr. Carl Buckley, Miss Miriam Boxberg. Behind me, Mr. Omar Solomon, Miss Poppy Henderson, and Mr. Admir Berisha.
Thank you, Mr. Cadman. Now I turn to the registry.
Good morning, Your Honours. On behalf of the registry is the registrar, Dr. Fidelma Donlan, and myself, Ralph Ridge. Thank you.
Thank you, Mr. Roche. Before we start, I would like to remind everyone of a few rules that must be observed at all times in order to make for a more effective courtroom with an accurate record. So please, before speaking, make sure your microphone is activated and switch it off as soon as you finish. Speak slowly and clearly as we have interpretation from and into Albanian and Serbian. In this way, the interpreters can do their work properly. Before intervening, wait 5 seconds in order to allow the interpreters to finish the interpretation of the previous sentence. I would also like to remind you that this hearing is held in open session unless otherwise requested by the parties or decided by the panel. So please give prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. I would also remind everyone to follow the in-court redactions procedure that we set out in our order for the conduct of proceedings. Today's hearing will proceed pursuant to Rules 124, 125, and 126 of the Rules of Procedure and Evidence of the Kosovo Specialist Chambers. First, the Specialist Prosecutor will read the indictment. Then, as presiding judge, I will ask the accused whether they understand the indictment, and I will give them an opportunity to confirm their initial plea. Further, I will inform the accused of their rights and obligations. Lastly, I will give the floor to the Specialist Prosecutor to make his opening statement. Before that step, I will give some instructions on the presentation of evidence for the coming weeks. Our plan is to finalize this hearing today by 4 p.m., but if the SPO needs more time to finish its opening statement, We may also sit for the first session tomorrow. Before we begin, I will provide a short procedural history of this case. On 25 and 26 September 2020, Hisni Gucati and Nasim Haradinaj were arrested in Kosovo and transferred to the Specialist Chambers detention facilities in The Hague, the Netherlands. On 30 October 2020, the Specialist Prosecutor submitted for confirmation before the pretrial judge an indictment against Mr. Gucati and Mr. Haradinaj. On 11 December 2020, the pretrial judge confirmed in part the indictment and ordered the Specialist Prosecutor's Office to submit a revised indictment as confirmed. On July 5, 2021, further to a decision of the Court of Appeals panel, the SPO filed a corrected indictment. On 16 July 2021, the pretrial judge transmitted the case file to the trial panel. On 8 September 2021, the panel set a date for the opening of the case for today, 7 October 2021, and decided that the presentation of the SPO case will begin on 18 October 2021. Now we will continue with the reading of the indictment as provided in Rule 124, Paragraph 2 of the Rules. Mr. Prosecutor, please read the unredacted version of the corrected indictment as filed on 5 July 2021. Where necessary, we will go into private session or closed session to read the confidential parts. Once out of the private session, the prosecutor will read the redacted version of the same text. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. I will now read the indictment into the record in accordance with Your Honor's instructions. As the defense has asked for previously, it will be the entire unredacted indictment. Certain paragraphs in the indictment refer to other paragraph numbers as cross-references. My understanding is that the defense wants these read into the record as well, so I will do so. And with that, I will begin. The Specialist Prosecutor, pursuant to his authority under Articles 35(2)I and 38 of Law Number 05L-053 on Specialist Chambers and Specialist Prosecutor's Office, or the law, charges Hisni Gucati and Nasim Haradinaj with criminal offenses against the administration of justice and public administration, and criminal offenses against public order, punishable under Chapters 2, 31, and 32 of the Criminal Code of the Republic of Kosovo, Code Number 06L-074, 2019, or the KCC, and Articles 15.2 and 16.3 of the law, as set forth below. The accused. Your Honors, at this point, we would request to go into private session for about 2 minutes to read the redacted portion into the record.
All right, Madam Court Officer, we will go into private session.
Your Honors, we're back in public session.
All right. You can proceed, Mr. Prosecutor.
Thank you, Your Honor. The accused, Hisni Gucati, son of a redacted name, was born on 30 March 1967 in Marin, Skenderaj Municipality, Kosovo. His last known residence is in a redacted address, Kosovo. He has Kosovan nationality, personal number, which is redacted. Nasim Haradinaj, son of a redacted name, was born on 21 May 1963 in Glojan, Deçan Municipality, Kosovo. His last known residence is in a redacted address, Kosovo. He has Kosovan nationality, personal number redacted. At all times relevant to this indictment, Hisni Gucati and Nasim Haradinaj were chairman and deputy chairman, respectively, of the Kosovo Liberation Army War Veterans Association, or the KLA-WVA. Statement of facts. All crimes charged in this indictment relate to official proceedings of the Specialist Chambers, or SC, including investigations of the Specialist Prosecutor's Office, or SPO, and collectively this is referred to as SC proceedings. All references to witnesses in this indictment should be understood to include any persons likely to have information about a crime, the perpetrator, or important circumstances relevant to SC proceedings. Between at least April and September 2020, Hisni Gucati and Nasim Haradinaj made statements accusing witnesses cooperating with the SPO and other persons of being, inter alia, liars, collaborators, and traitors. This conduct demonstrates their intent and motive to undermine and obstruct SC proceedings. As set out below, between at least 7 and 25 September 2020, Hisni Gucati, Nasim Haradinaj, Faton Kliniku, the KLA-WVA secretary, Tomigashi, KLA-WVA legal counsel, and other members and representatives of the KLA-WVA, collectively with Faton Kliniku and Tomigashi called associates, disseminated without authorization, confidential and non-public information relating to the confidential investigations of the Special Investigative Task Force, or SITF, and SPO, encouraged others to further disseminate confidential and non-public information, and undertook other actions for the declared purpose of obstructing the SC/SPO. This confidential and non-public information included documents marked confidential and the names, personal data, and evidence of hundreds of witnesses under protection in the context of SC proceedings and prior criminal proceedings in or relating to Kosovo. Hisni Gucati and Nasim Haradinaj organized and coordinated the unauthorized dissemination and related actions, including by, with associates, reviewing the confidential and non-public information, partaking in decisions as to whether and how to disseminate it, and organizing and participating in related events, including press conferences and public appearances, where confidential and non-public information was publicly disseminated and discussed. First disclosure. On 7 September 2020, Hisni Gucati and Nasim Haradinaj, acting in their capacities as head and deputy head of the KLA-WVA, held a press conference at which Hisni Gucati announced that the KLA-WVA had received files relating to the SC/SPO. This is known as the first press conference. These files, known as the first disclosure, were laid out on a table during the press conference. Nasim Haradinaj stated that 4 copies of the documents were being made available at the first press conference. He announced the names, places of residence and employment, or other personal data of 4 witnesses. Nasim Haradinaj also explained that the names, places of residence, telephone numbers, other personal data, statements, and information relating to the interviews of other witnesses, including Albanians, Romas, and Serbs, were in the first disclosure. Nasim Haradinaj acknowledged the confidential nature of the documents. He stated that the KLA-WVA would send a copy of the documents to members of the Kosovo Assembly and would give those attending the first press conference as many copies as they wanted. Nasim Haradinaj urged those in attendance to take a copy of the documents and to review the witnesses' names and statements. On 7 September 2020, the SC single judge authorized the seizure of documents forming part of the first disclosure, recognized the confidential and non-public nature of information from SITF/SPO investigations, and ordered that any individual in possession of the documents or their contents refrain from copying, recording, or disseminating them. This is known as the first order. On 8 September 2020, the SPO served the first order and seized the documents at the KLA-WVA premises. The seized items included confidential and non-public information relating to confidential investigations, including the identities, personal data, and evidence of witnesses. After the first press conference, between 7 and 15 September 2020, Hisni Gucati and Nasim Haradinaj made multiple public statements relating to the first disclosure. As part of such statements, Hisni Gucati and or Nasim Haradinaj publicly, 1. Confirmed that copies of the first disclosure had been provided to members of the press. 2. Disclosed further contents of the first disclosure, including details of the confidential investigations. 3. Stated that witnesses were named in the documents and referred to the dates and locations of specific interviews. 4. Accused witnesses named in the documents of being, inter alia, liars, traitors, and spies. 5. Encouraged.
Excuse me, Mr. Howling, we're having a technical problem again.
It keeps clicking offline.
Yes, we're going to have someone take a look at it.
Interpreter's note, we apologize, but we still cannot hear counsel.
In order to deal with this, the technician needs to have a stop the proceedings for the time being for maybe 10 minutes. So we will step aside. We are adjourned for a 10-minute period. Please stay close.
All rise.
Sorry for the interruption. Everyone, apparently we are possibly bumping the connection. None of us have a lot of room, so let's be mindful of where our documents and whatnot are and try to avoid the hookup for the system. Mr. Helling, you can continue.
Thank you, Your Honor. I'll start from the beginning of the paragraph where we
Okay,
paused.
that's fine. Thank you.
After the first press conference between 7 and 15 September 2020, Hisni Gucati and Nasim Haradinaj made multiple public statements relating to the first disclosure. As part of such statements, Hisni Gucati and or Nasim Haradinaj publicly, 1, confirmed that copies of the first disclosure had been provided to members of the press. 2, disclosed further contents of the first disclosure, including details of the confidential investigations. 3, stated that witnesses were named in the documents and referred to the dates and locations of specific interviews. 4, accused witnesses named in the documents of being, inter alia, liars, traitors, and spies. 5, encouraged members of the press to publish documents contained in the first disclosure. 6, declared that if they received further confidential and non-public information, they would publicly disseminate it. And 7, stated that they did not recognize the SC/SPO and that their actions were intended to obstruct the SC/SPO. After the first press conference and over the following days, certain members of the press and public further disseminated contents of the first disclosure, including witness names and personal data in the press and online. Second disclosure. On 16 September 2020, Hisni Gucati and Nasim Haradinaj, acting in their capacities as head and deputy head of the KLA-WVA, held a press conference, or second press conference, at which Hisni Gucati stated that the KLA-WVA had received another set of documents. He told those who were present that they could take the documents. It is known as the second disclosure. While showing one of the documents, Hisni Gucati named 2 persons who had cooperated with the SITF. Nasim Haradinaj repeated the name of one of the persons already identified by Hisni Gucati, named another person who cooperated with the SITF, and revealed other confidential and non-public information relating to the confidential investigations. Nasim Haradinaj told those present at the second press conference that the documents were available for anyone and told those present to take them. On 17 September 2020, the SC single judge authorized the seizure of documents forming part of the second disclosure, recognized the confidential and non-public nature of information from SITF/SPO investigations, and ordered that any individual in possession of the documents or their contents refrain from copying, recording, or disseminating them. This is known as the second order. Later that day, the SPO served the second order and seized documents at the KLA-WVA premises. The seized items included 1, documents relating to prior criminal proceedings in Kosovo and before the International Criminal Tribunal for the former Yugoslavia, and 2, documents relating to confidential investigations, which had also formed part of the first disclosure and included the identity or personal data of at least 3 witnesses. After the second press conference, between 17 and 21 September 2020, Hisni Gucati, Nasim Haradinaj, and Tomigashi made multiple public statements relating to the first disclosure and second disclosure. As part of such statements, Hisni Gucati and or Nasim Haradinaj publicly, 1, acknowledged the sensitive, confidential, and non-public nature of the contents of the first disclosure and second disclosure. 2, acknowledged that, by law, witness identities and personal data should not be published. 3, claimed that the documents seized by the SPO formed only part of the documents disseminated during and after the second press conference, as the rest had already been taken by members of the press and others. 4, acknowledged that SC orders forbade further dissemination of the contents of the first disclosure and second disclosure. 5, confirmed that the second disclosure had been made available to and taken by members of the press. 6, disclosed further contents of the first disclosure and second disclosure, including details of the confidential investigations. 7, confirmed that documents disseminated include names and personal data of witnesses. 8, accused witnesses referred to in the confidential information of being, inter alia, liars, spies, and traitors. 9, thanked and praised the persons who had provided the second disclosure to the KLA-WVA. 10, promised to publish any further confidential and non-public information relating to the SC/SPO provided to the KLA-WVA. 11, challenged members of the press for not publishing confidential and non-public information. 12, told members of the press to publish confidential and non-public information. And 13, stated that they did not recognize the SC/SPO and that their actions were intended to obstruct the SC/SPO. Third disclosure. On 22 September 2020, Hisni Gucati and Nasim Haradinaj, acting in their capacities as head and deputy head of the KLA-WVA, held a press conference, or the third press conference, at which Hisni Gucati stated that the KLA-WVA had received documents which they believed had been leaked from the SC/SPO. This is known as the third disclosure. Hisni Gucati showed one of the documents, inviting those in attendance to move closer to view it. Your Honors, at this point, we would ask again to move into private session for the purpose of reading redacted information. It should take about 3 minutes.
Your Honors, we're in public session.
Go ahead, Mr. Helling. We are in public session.
Thank you, Your Honor. Picking up where I left off for the benefit of the public. On 22 September 2020, the SPO issued an order for the production of documents forming part of the third disclosure, and that any individual in possession of the documents or their contents refrain from copying, recording, or disseminating them. This is known as the third order. That same day, the SPO served the third order and seized documents at the KLA-WVA premises. The seized items included confidential and non-public information relating to confidential investigations, including the identities, personal data, and evidence of witnesses. After the third press conference, between 22 and 25 September 2020, Hisni Gucati and Nassim Haradinaj made multiple public statements relating to the third disclosure. As part of such statements, Hisni Gucati and or Nassim Haradinaj publicly, 1. Confirmed that the third disclosure was disseminated to the press. 2. Something which is redacted. 3. Encourage persons with confidential and non-public information relating to the SC/SPO to continue to provide it to the KLA-WVA. 4. Promise to publish any further confidential and non-public information relating to the SC/SPO provided to the KLA-WVA. And 5. Stated that they did not recognize the SC/SPO and that their actions were intended to obstruct the SC/SPO. Following the third press conference and over the following days, certain members of the press and public further disseminated contents of the third disclosure, including witness names and evidence in the press and online. As a result of the first disclosure, second disclosure, third disclosure, and related events set out above, witnesses and or their family members were intimidated. Their safety, privacy, reputations, and livelihoods were threatened. Further, the SPO was forced to take measures to address actual and potential consequences, including to witnesses and SC proceedings. The confidential and non-public documents disseminated as part of the first disclosure, second disclosure, and third disclosure are hereinafter referred to as the confidential information. Crimes. Based on the facts set out in paragraphs 4 to 22, Hisni Gucati and Nassim Haradinaj are individually criminally responsible for each of the following crimes. As set out in paragraphs 45 to 46, they had the requisite knowledge and intent for each crime. Obstructing official persons in performing official duties. Between at least 7 and 25 September 2020, Hisni Gucati, Nassim Haradinaj, and associates, by serious threat and common action, obstructed or attempted to obstruct SC proceedings. Hisni Gucati and Nassim Haradinaj organized and coordinated the group committing such acts. In particular, as set out in paragraphs 6 to 9, 11 to 14, 16 to 18, and 20 to 21, on multiple occasions between at least 7 and 25 September 2020, Hisni Gucati, Nassim Haradinaj, and associates, 1, disseminated the confidential information, 2, accused witnesses identified in the confidential information of being, inter alia, liars, spies, and traitors, and 3, declared that their purpose in disseminating the confidential information and related acts was to obstruct SC proceedings. Hisni Gucati and Nassim Haradinaj also publicly encouraged, instructed, and advised, 1, certain members of the public in possession of or with access to confidential information relating to SC proceedings to continue providing it to the KLA-WVA, and 2, certain members of the press and public to take or record and further disseminate and publish confidential information. Following at least the first disclosure and third disclosure, certain of the confidential information was further disseminated in the press and online, as set out in paragraphs 12 and 21. Finally, as set out in paragraph 22, the acts of Hisni Gucati, Nassim Haradinaj, and associates obstructed or attempted to obstruct SC proceedings. 1, witnesses were intimidated. 2, the SPO's ability to effectively investigate and prosecute crimes, including by obtaining and securing relevant evidence, was thereby threatened. And 3, SPO resources and time were diverted to address actual and potential consequences, including to witnesses and SC proceedings. Intimidation during criminal proceedings. Between at least 7 and 25 September 2020, Hisni Gucati, Nassim Haradinaj, and associates used serious threats to induce or attempt to induce witnesses to refrain from making a statement or to make a false statement or otherwise fail to state true information to the SPO and SC. In particular, as set out in paragraphs 6 to 9, 11 to 14, 16 to 18, and 20 to 21, on multiple occasions, Hisni Gucati, Nassim Haradinaj, and associates, 1, disseminated the identities, personal data, and evidence of hundreds of witnesses to members of the press and public. 2, acknowledged that the confidential information included the identities and data of protected witnesses. 3, in public appearances, revealed witness identities, their places of residence, and other personal data and details, including dates and locations of witness interviews. 4, accused witnesses identified in the confidential information of being, inter alia, liars, spies, and traitors. 5, encouraged, instructed, and advised certain members of the public in possession of or with access to confidential information relating to SC proceedings to continue providing it to the KLAWVA. 6, encouraged, instructed, and advised certain members of the press and public to take or record and further disseminate and publish confidential information. 7, declared that, and by their actions demonstrated, their indifference to the safety of witnesses identified in the confidential information. And 8, declared that their purpose in disseminating the confidential information and related acts was to obstruct SC proceedings. Retaliation. Between at least 7 and 25 September 2020, Hisni Gucati, Nasim Haradinaj, and associates took or attempted to take actions harmful to witnesses with the intent to retaliate for providing truthful information relating to the commission or possible commission of criminal offenses to the SPO. In particular, the acts and omissions described in paragraph 30 above infringe the witness's fundamental rights as guaranteed in the Constitution of the Republic of Kosovo and the European Convention on Human Rights. Witnesses and/or their family members were intimidated. Their safety, privacy, reputations, and livelihoods were threatened. Violating the secrecy of proceedings. As set out in paragraphs 6 to 9, 11 to 14, 16 to 18, and 20 to 21, between at least 7 and 25 September 2020, Hisni Gucati, Nasim Haradinaj, and associates, without authorization, revealed confidential information. They also encouraged, instructed, and advised, 1, certain members of the public in possession of or with access to confidential information relating to SC proceedings to continue providing it to the KLAWVA. And 2, certain members of the press and public to take or record and further disseminate and publish confidential information. The confidential information must not be revealed according to the law and/or was classified by competent authorities, including the SC, SITF/SPO, and cooperating organizations and states pursuant to an agreement with the SITF/SPO. The information was classified in accordance with Articles 4.2, 23, 35, 2D to F, 39, 54.8, 61.3 to 4, and 62 of the law. Further, as set out in paragraphs 6 to 9, 11 to 14, 16 to 18, and 20 to 21, between at least 7 and 25 September 2020, Hisni Gucati, Nasim Haradinaj, and associates, without authorization, revealed or attempted to reveal the identities and personal data of witnesses under protection in SC proceedings and prior criminal proceedings in Kosovo. They also encouraged, instructed, and advised members of the press and public to reveal such information without authorization. Hisni Gucati, Nasim Haradinaj, and associates publicly stated that the confidential information included identities, personal data, and evidence of witnesses and related to confidential SITF/SPO investigations. Hisni Gucati, Nasim Haradinaj, and associates acknowledged that the identities and personal data of witnesses should not, by law, be publicly disseminated. Rather, in accordance with the law, the confidential information should only have been disclosed in the context of criminal proceedings, subject to appropriate safeguards and protective measures. As set out in paragraphs 22 and 32 above, the unauthorized revelation of protected witness identities and personal data resulted in serious consequences for the witnesses and severely hindered SPO investigations. Modes of liability. based on the facts set out in paragraphs 4 to 22, Hisni Gucati and Nassim Haradinaj are individually criminally responsible for the crimes described above through the following modes of liability. As set out in paragraphs 45 to 46, they had the requisite knowledge and intent for each mode of liability and crime. Commission and attempt. Hisni Gucati and Nassim Haradinaj committed the crimes through the acts and omissions described above in paragraphs 6 to 9, 11, 13 to 14, 16 to 18, and 20. In addition, or the alternative, through the acts and omissions described in paragraphs 6 to 9, 11, 13 to 14, 16 to 18, and 20, Hisni Gucati and Nassim Haradinaj attempted, within the meaning of KCC Article 28, the commission of the crimes of obstructing official persons in performing official duties, intimidation during criminal proceedings, retaliation, and violating the secrecy of proceedings through the revelation of the identities and personal data of protected witnesses. Co-perpetration, an agreement to commit criminal offense. As demonstrated by their declared purpose to obstruct the SC/SPO and concerted acts in furtherance of this common purpose, as described in paragraphs 6 to 9, 11 to 14, 16 to 18, and 20 to 21, Hisni Gucati, Nassim Haradinaj, and associates committed the crimes in co-perpetration and or agreed to commit the crimes. Hisni Gucati and Nassim Haradinaj substantially contributed to and undertook substantial acts toward the commission of the crimes in furtherance of their common purpose or agreement, including in one or more of the following ways, as described in more detail in paragraphs 6 to 9, 11, 13 to 14, 16 to 18, and 20. 1. Reviewing the confidential information. 2. Deciding or partaking in decisions about whether and how to disseminate it. 3. Organizing and partaking in events, including press conferences and public appearances, where confidential information was publicly disseminated and discussed. 4. Disseminating the confidential information. 5. Revealing the identities and personal data of witnesses, including protected witnesses. 6. Making accusations against and derogatory comments about witnesses. 7. Encouraging and advising persons with access to confidential information relating to SC proceedings to continue providing it to the KLAWVA and promising to continue disseminating such confidential information. And or 8, encouraging, instructing, and advising members of the media and public to take or record and further disseminate the confidential information. Incitement.
Nżidja.
Paragraph 42 to 8, Hisni Gucati and Nassim Haradinaj incited one another, associates, and others, namely, 1, the persons who, remotely or in person, attended, observed, or were otherwise informed of the 3 press conferences and other public statements described in paragraphs 8 to 9, 11, 13 to 14, 16 to 18, and 20 above. 2, certain members of the press. And 3, persons in possession of or with access to confidential and non-public information relating to SC proceedings, collectively known as other persons, to commit the crimes described above. In addition, or in the alternative, through one or more of the acts described in paragraph 42 to 8, Hisni Gucati and Nassim Haradinaj, 1, incited one another, associates, and other persons to commit the crimes of obstructing official persons in performing official duties, intimidation during criminal proceedings, retaliation, and violating the secrecy of proceedings. And 2, such crimes were attempted. In addition, or in the alternative, through one or more of the acts described in paragraph 42 to 8, Hisni Gucati and Nassim Haradinaj, 1, incited one another, associates, and other persons to commit the crimes of obstructing official persons in performing official duties, intimidation during criminal proceedings, and violating the secrecy of proceedings through the revelation of the identities and personal data of protected witnesses. And 2, such crimes were neither committed nor attempted. Assistance. Finally, through one or more of the acts described in paragraph 40, Hisni Gucati and Nasim Haradinaj provided assistance to one another, associates, and other persons in the commission of the crimes described above. Intent. As demonstrated by their deliberate conduct and statements described in paragraphs 5 to 9, 11 to 14, 16 to 18, and 20 to 21, including dissemination of the confidential information, accusations against witnesses, indifference to witness safety, statements acknowledging the confidential nature of the confidential information, and declared purpose to obstruct the SC/SPO. Hisni Gucati, Nasim Haradinaj, and as applicable, associates and other persons intended the commission of the crimes described above, and to incite and assist the commission of the crimes. In the alternative, as demonstrated by their deliberate conduct and statements, Hisni Gucati, Nasim Haradinaj, and as applicable, associates and other persons, 1, were aware that the crimes described above could occur as a result of their acts or omissions, and that their acts or omissions could incite or assist in the commission of crimes, and 2, acceded to their occurrence. Statement of crimes. Through the acts and omissions described above, Hisni Gucati and Nasim Haradinaj, 1, committed, alone or in co-perpetration, the crimes of obstructing official persons in performing official duties, intimidation during criminal proceedings, retaliation, and violating the secrecy of proceedings. 2, attempted to commit the crimes of obstructing official persons in performing official duties, intimidation during criminal proceedings, retaliation, and violating the secrecy of proceedings through the revelation of the identities and personal data of protected witnesses. 3, agreed to commit the crimes of obstructing official persons in performing official duties, intimidation during criminal proceedings, retaliation, and violating the secrecy of proceedings, and took substantial acts towards the commission of these crimes. 4, incited and assisted in the commission of the crimes of obstructing official persons in performing official duties, intimidation during criminal proceedings, retaliation, and violating the secrecy of proceedings. 5, incited the commission of the crimes of obstructing official persons in performing official duties, intimidation during criminal proceedings, retaliation, and violating the secrecy of proceedings, and such crimes were attempted, and or 6, incited the commission of the crimes of obstructing official persons in performing official duties, intimidation during criminal proceedings, and violating the secrecy of proceedings through the revelation of the identities and personal data of protected witnesses, and such crimes were neither committed nor attempted. Hisni Gucati and Nasim Haradinaj are individually criminally responsible for count 1, obstructing official persons in performing official duties by serious threat between at least 7 and 25 September 2020, a criminal offense against public order punishable under KCC Articles 17, 28, 31, 32, 1-3, 33, 35, and 401, 1 and 5, and Articles 15.2 and 16.3 of the law. Count 2, obstructing official persons in performing official duties by participating in the common action of a group between at least 7 and 25 September 2020, a criminal offense against public order punishable under KCC Articles 17, 28, 32, 1-3, 33, 35, and 401, 2-3 and 5, and Articles 15.2 and 16.3 of the law. Count 3, intimidation during criminal proceedings between at least 7 and 25 September 2020, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 17, 28, 31, 32, 1 to 3, 33, 35, and 387, and Articles 15, 2 and 16, 3 of the law. Count 4, retaliation, between at least 7 and 25 September 2020, a criminal offense against the administration of justice and public administration, punishable under KCC Article 17, 28, 31, 32, 1 to 2, 33, 35, and 388, 1, and Articles 15, 2 and 16, 3 of the law. Count 5, violating secrecy of proceedings through unauthorized revelation of secret information disclosed in official proceedings between at least 7 and 25 September 2020, a criminal offense against the administration of justice and public administration, punishable under KCC Article 17, 31, 32, 1 to 2, 33, 35, and 392, 1, and Articles 15, 2 and 16, 3 of the law. And count 6, violating secrecy of proceedings through unauthorized revelation of the identities and personal data of protected witnesses between at least 7 and 25 September 2020, a criminal offense against the administration of justice and public administration, punishable under KCC Articles 17, 28, 31, 32, 1 to 3, 33, 35, and 392, 2 to 3, and Articles 15, 2 and 16, 3 of the law. All sections of this indictment should be read in conjunction with one another. And Your Honors, that concludes the reading. Thank you.
Thank you, Mr. Halling. I now have some questions for the accused. First, Mr. Gucati, would you please stand? I'm asking you, Mr. Gucati, in accordance with Rule 124, Paragraph 3, whether you understand the indictment.
Yes, I do.
Mr. Gucati, during your initial appearance on 18 December 2020, you pleaded not guilty to all counts of the confirmed indictment. You have now the opportunity to confirm this plea. Do you confirm your initial plea?
So before that, I want to have 2 minutes of time in order for myself to provide you with an overview of my biography, if that's possible at all.
You ask the questions that I've asked, and we will deal with anything else later. So you need to respond whether you are still confirming your plea of not guilty.
I am innocent. I have no connection to any of the points in the confirmed indictment.
By that statement, are you saying you confirm your plea of not guilty, yes or no?
I feel innocent. I do not feel guilty for any of the points of the indictment that has been raised against me. Thank you.
Now, Mr. Haradinaj, would you please stand? I'm going to ask you the same questions that I just asked to Mr. Gucati. I'm asking you in accordance with Rule 124, Paragraph 3, whether you understand the indictment. Yes or no?
I am innocent and I'm always against injustice.
Indictment, yes or no?
As a matter of fact, I cannot understand this type of an indictment, but I heard everything that you read. Of course, yes. But I didn't understand the gist of it.
Stop and ask questions of your attorney.
No, I don't.
Further to your refusal to enter a plea on January 8th, 2021, the pretrial judge entered on your behalf a plea of not guilty on all charges in the confirmed indictment. Do you wish to confirm this plea? Is that still your plea?
I'm innocent. Thank you.
Of some important rights that are afforded to you before this court pursuant to its legal framework. You have the right to remain silent without such silence being a consideration in the determination of innocence or guilt. You have the right not to be compelled to confess guilt or to testify. You have the right not to incriminate yourself or your immediate family members. You have the right to be represented by a counsel. I note that both of you are represented by specialist counsel. You have the right to have adequate time and facilities for the preparation of your defense and to communicate with your counsel. You have the right to be tried within a reasonable time. You have the right to examine or have examined the witnesses against you and to obtain the attendance and examination of witnesses on your behalf. And you have the right to make an unsworn statement relevant to the case and may appear as a witness under oath. Mr. Gucati and Mr. Haradinaj, I have advised you of your rights. But before we go any further, I'm also required by our rules to inform you of your obligations and the measures provided for pursuant to Rule 61, subparagraph 2 of the rules. As presiding judge, I oversee the order in the courtroom and in the public gallery, as well as the conduct of all participants. Although I do not expect it to be necessary, it is my duty to advise you, Mr. Gucati and Mr. Haradinaj, that as presiding judge, I may order your temporary removal from the courtroom and continue the proceedings in your absence if you persist in disruptive conduct following a warning that such conduct may result in your removal from the courtroom. During any removal, your interests will be represented by your counsel. This panel will make provisions for you to observe the proceedings and to instruct your counsel from outside the courtroom. However, as I stated, I trust that this type of action will not be necessary. And for everyone else in the courtroom and in the public gallery, I remind you that as presiding judge, I may take appropriate action and measures, including the removal of a person in order to protect the right of the accused to a fair and public trial, or to maintain the dignity and decorum of the proceedings, and I may also order a personal search of any person in the courtroom and the public gallery as necessary for security reasons or for the proper administration of justice. Now, before giving the floor to the specialist prosecutor to make his opening statement, which we will probably do after the morning break, I want to raise some issues of concern to the panel. The material that the accused are said to have unlawfully publicized contain names and details of various individuals who are connected to investigations carried out by the SITF or the SPO. Until that time when the panel determines whether that material was or still is confidential in nature, the parties are ordered not to make public reference to this information in public hearings. We therefore expect the parties to exercise due diligence in ensuring that the names and details of such individuals are not disclosed in public sessions, whether in their opening statements, questioning of witnesses, or submissions. If necessary, the parties should request private session if the name or function of any such individual is deemed material to a question they wish to ask or submissions they wish to make. Please consider this an official warning. I also want to make a general statement concerning redactions and closed and private sessions. This panel is guided by the fact that trials are intended to be public, so that the public knows and has confidence in the judicial process as well as an understanding of the issues and decisions in the trial. This belief is reinforced by our rules of procedure and evidence. Redacting names and personal identification of witnesses, victims, and others at risk on account of testimony given by witnesses is of course possible, and when ordered by the panel, a necessary exception to the general rule. That being said, we will be guided by the general rule of publicity and will not be admitting into evidence documents with what is considered by the panel as excessive redactions that render documents unintelligible and which would leave the general public in a state of ignorance concerning the details of the document offered. Private and closed sessions should also be used sparingly and the exception rather than the rule. Counsel are instructed to plan their direct and cross-examinations carefully, and in so doing to endeavor to group together any questions that must be asked and answered in private or closed session to avoid repetitive closings. Lastly, I remind all parties to comply with the instructions in the order on the conduct of proceedings. In addition, the parties are informed that during the presentation of evidence, parties are expected to use the presentation cue tool in legal workflow when questioning witnesses, as described in the order on conduct of proceedings. Evidence shown in the courtroom will not be broadcast publicly unless the panel orders otherwise. When referring to any material during the questioning of a witness, the examining party shall identify such material by reference to the relevant exhibit number, if already admitted, or ERN number, and shall also indicate the corresponding page referenced in the Albanian or English, depending on the language of the particular material. And rather than interrupt the opening statement after just a few minutes, we will break now for the morning session, but I would ask you to be back at 10:20 or 11:25, at which time we will take up the opening statements. So we are in recess at this time, and we will see you in 30 minutes. Can this wait?
Your Honour had indicated that you were going to make a decision on what Mr. Rees had indicated before the opening.
Pardon me?
Your Honour had indicated earlier that you were going to make an oral order on the matter that Mr. Rees had raised earlier before the opening of the prosecution.
The oral order, I've already mentioned, the oral order is that the Rule 117.2 requests made both by you and by Mr. Rees separately are overruled, and a written decision is in the process and will be filed shortly.
My question was going to be, when could we have an estimate of the time, because the evidence is going to be presented by the prosecution on the 18th, and we have to consider
it will be, you'll have it early in the week, perhaps as early as tomorrow.
Thank you.
All right. We are in recess.
All rise. rise.
Before I give the floor to the Specialist Prosecutor's Office, I would like to make it clear that pursuant to Rule 126, the opening statement of the SPO does not constitute evidence. It gives, however, an opportunity for the SPO to present an overview and give notice of the case it will endeavor to prove at trial. Mr. Prosecutor, the floor is yours.
Your Honors, Madam Registrar, Counsel, good morning. As Specialist Prosecutor, I am pleased to have the privilege of addressing you today as we begin the second trial of this court. The trial we begin today is different than the trial that began last month or others that will follow, in that the charges here do not directly concern the events of the war in Kosovo occurring over 20 years ago. Instead, the charges concern events that occurred just last year. They concern attempts to intimidate people into not telling this court what happened to them 20 years ago, and attempts to obstruct the work of this institution at any cost. They concern the climate of interference and intimidation that exists in cases and investigations regarding former KLA members, which the accused sought to inflame for their own advantage. Your Honors, this is a case about the conditions required for the fair administration of justice and attempts by the accused to block the path of justice for so many. This is a case about what is required to make rule of law a reality. In any society, the fair administration of justice requires building and fostering institutions that can protect those who seek justice. This court was created by a law passed in Kosovo, and it has the ability to do justice for many, many Kosovar victims. The reason it has this power is that it represents a safe place for witnesses to speak openly about the crimes they saw, the crimes that they themselves were subject to, and the crimes they saw their family members subject to. Most crucially, it represents a place where they can do so without fear of retaliation or retribution. This court can only work if witnesses feel safe to tell their stories. Our ability as an institution to protect witnesses and their families from intimidation, retribution, and worse is the foundation upon which any effective tribunal of this nature must be built. Put very plainly, the Kosovo Specialist Chambers cannot effectively execute on its mandate if conduct like that of the accused is permitted to occur. If we believe this court and courts like it are a good thing, we must empower them fully to protect the very people they serve. This court was in fact built to do just that. That is why those who drafted our law and created this court specifically included within its jurisdiction several of the very crimes that are charged in this case: intimidation during criminal proceedings, retaliation, obstruction of official persons by serious threat, and violation of the secrecy of official proceedings by revealing the identity of protected persons. The statutes the accused are charged with violating are themselves a recognition of the need to empower this institution to protect witnesses and to protect victims. The proof that we will offer that the accused, in fact, violated each of these statutes will make clear beyond any reasonable doubt that their intention was to obstruct this institution and to make witnesses fear for their safety. The evidence in this case will show that the accused acted with criminal intent and that their actions and their words had no legitimate or legal purpose. On this point, I want to be very clear. Vigorous debate on important public issues is a sign of a healthy society. Rather than be suppressed, of course, it should be fostered. There are people in Kosovo who believe very strongly in this institution. They see it as a sign of Kosovo's commitment to the rule of law and a place that will give justice to many victims. Others do not yet trust this court, and that is okay. It is okay to question aspects of this court. It is okay to say what you do not like about this court, and it's okay to say why you do not like this court. That is all part of a free society. As I've said in the past, all I ask is that people who do not yet trust this court take the time to follow it closely, to see how it functions, and then judge. I'm confident that if they do, they'll discover that this institution, an institution created by the people of Kosovo, will do justice for a great many Kosovar victims. What you cannot do in a free society, however, is obstruct justice. What you cannot do is publicly disseminate confidential information that contains the names of witnesses, and do so with a clear intent to intimidate those witnesses. Truth is the foundation of justice, and there are a few truths that explain why we are here today. These truths help explain the case before the court and the context in which the accused committed the crimes charged here. The first truth is that there is a small but powerful group of persons in Kosovo that do not want this court to exist and that will do anything to damage it in a vain attempt to salvage a false narrative that no KLA soldiers committed any crimes during this war. As the people who oppose this court know well, the cases my office brings and the facts that will be brought to light during these trials held in this courtroom, they will leave no doubt that this narrative is not true. But this false narrative, it is important enough to certain KLA leaders that they will do anything to prevent information coming to light, facts coming to the public that show it to be untrue. The accused are part of this group. They want this court to go away at any cost. Mr. Gucati and Mr. Haradinaj are vocal opponents of this institution, denigrating anyone who would recognize or cooperate with the Kosovo Specialist Chambers or the Specialist Prosecutor's Office as spies, collaborators, and traitors who betrayed their fellow countrymen, despite the fact that this is an institution created by the people of Kosovo and for the people of Kosovo. A second truth is that our institution cannot effectively work towards its mandate if victims and witnesses are too frightened to cooperate. This, Your Honors, is a hard reality, but it is a reality nonetheless. And it is a reality that the accused know well. We as an institution must not only be able to protect witnesses, we must be able to inspire their confidence that we can, in fact, protect them. The accused know this, and as the evidence will show in this trial, their intent was to disclose confidential information, to retaliate against witnesses for their cooperation with my office, and to sow distrust in this institution and its ability to protect witnesses. Mr. Haradinaj left little doubt of this when on September 20th of last year, during the course of committing these crimes, he directly addressed the witnesses in this case on a television program, stating, and I quote, "You spies, do not think that someone will protect you." He then added that the court will, quote, "totally collapse because the witnesses too know now that others know who they are." Your Honors, this should be a victim-driven court, and the intent of the accused in this case was to inspire fear in victims. To fully understand why the accused thought they could do this through their actions requires an understanding of the context in which they committed these crimes, including the pressure felt by many in Kosovo not to come forward and not to tell the truth about what they saw and what they experienced during the war. Part of the reason this court was created, and certainly why it has been located here in The Hague, was the often recognized climate of intimidation of witnesses and interference with proceedings that exists in criminal cases against former KLA members. That climate continues to exist today, and it was the accused plan to intensify that climate so that witnesses would fear for their safety if they cooperated and seek and end their cooperation with the court. It is a reality that this climate has worked in the past to prevent witnesses from coming to court to say what they knew about KLA crimes. The accused know this history well and hope to use the same strategy here to intimidate witnesses because it had worked in the past. Now, with respect to the charges in this case, I would like to make clear to everyone what is charged in this case and what is not charged in this case. Disseminating confidential documents, the documents in question in this case, disseminating them to the public represents one group of crimes. Stealing those same documents in the first place represents another crime. The accused are charged with illegally disseminating these documents, not with actually stealing them. And to be very clear, we are actively investigating the theft of those documents in question, and make no mistake, when we accumulate sufficient evidence against the individuals who did that, those individuals will be arrested and they will be brought to this very same courtroom to face charges for their crimes. As that is a separate, ongoing, and confidential investigation, I will not mention any of the details regarding it here today or its progress. But I do want to make one thing unequivocally clear to everyone. If you commit crimes intending to interfere with witnesses or to retaliate against witnesses, you will be charged. On this particular point, my office will be unrelenting and unstopping. We need to be, for the sake of the victims and witnesses who've placed their trust in this institution, to do justice. The accused in committing their crimes tried to amplify the damage they caused by exhorting the media in Kosovo to publish and further disseminate the confidential material in question in this case. In fact, the evidence will show that immediately after receiving each batch of material, they hastily convened a press conference just for that very purpose. The videos of those press conferences will be presented in the course of this case, and they will constitute incontrovertible proof of the accused's crimes and their criminal intent. Immediately after the events which formed the basis of this case, I issued a public statement commending the ethical journalists of Kosovo who refused to publish the documents that the accused attempted to provide them. Several of whom, in different forums, acknowledged that participating in the dissemination of such information was a crime. These same journalists, as well as others in Kosovo, have also spoken eloquently about how such activities undermine the rule of law and the pursuit of justice in Kosovo. Today, I would like to again thank the ethical journalists of Kosovo. The accused in plotting their crimes badly misjudged how the media in Kosovo would handle this event. We will offer evidence of the accused, and particularly Mr. Haradinaj, berating members of the media for not publishing more of the material the accused sought to provide them. While the accused had hoped all the media would publish witnesses' names and personal information and scare off anyone from cooperating with this court, that is not in fact what happened. The public, this court, and the accused should know that their efforts to stop this institution have failed. Make no mistake, the accused's actions did seriously obstruct my office, causing my staff to divert significant resources to deal with their actions, and seriously hindering my office's investigations. The accused's actions did cause real fear and real anxiety for witnesses and victims throughout Kosovo and elsewhere. Ultimately, however, their efforts to thwart the progress of justice, their efforts to cause the total collapse of this institution have failed. That they did not achieve their ultimate objective makes them no less guilty of the crimes with which they've been charged. That they were not able to close this court in no way diminishes the intent of what they sought to do or the very real effect it had on witnesses and the Specialist Prosecutor's Office. The accused underestimated the strength and the resilience of this institution and of the people who work here, people who are committed to the mission of justice. Most importantly, they greatly underestimated the will and the courage of the people of Kosovo who have cooperated with this court, people who have waited 20 years for justice. Thank you, Your Honors, for the opportunity to address you this morning. I will now turn the floor over to Prosecutor Bellici, who will set forth to Your Honors and to the public in further detail the case we will present and how we will prove the accused are personally responsible for the crimes with which they've been charged. Thank you.
Thank you, Mr. Smith. Ms. Bellici, you have the floor.
Thank you, Your Honor. As you just heard from the words of the specialist prosecutor, this case is about two men, Hisni Gucati and Nasim Haradinaj, who were so determined in their opposition to what this court stands for that they were willing to commit crimes to try to undermine and even stop its work. The evidence will show that in an effort to stop justice from happening in this court, the two accused themselves broke the law. Over the course of 19 days, in September 2020, Hisni Gucati and Nasim Haradinaj repeatedly disseminated confidential information of the Special Investigative Task Force for Kosovo and of the Specialist Prosecutor's Office, with the sole aim of obstructing the work of this court by intimidating witnesses and retaliating against them. The evidence will show that the accused knew what they were doing at every step. They acted willfully, and they continued to commit crimes even when told that they were breaking the law. The story of this case begins in the morning of the 7th of September 2020, when an unidentified man walked into the premises of the KLA War Veterans Association in Pristina and departed a few moments later, leaving behind a cardboard box. During the roughly 3 hours that followed, Mr. Gucati and Mr. Haradinaj found hundreds of pages of confidential documents pertaining to SITF investigation, looked through the documents, made a detailed assessment of the kinds of information contained in the documents, and recognized that they were confidential. Did the accused at this point contact the Specialist Prosecutor's Office to tell them that they had received confidential documents? No. Did they reach out to the judges of this court to tell them about the documents, or the Kosovo police? No. Did they take any steps to report to any authority that they had received confidential documents? No. They took none of these steps. What did they do instead? They immediately organized a press conference in order to make the documents public, in order to disseminate them as quickly as possible before anyone could stop them. They summoned the media to their office, and approximately 3 hours after they had received the documents, they held a press conference and shared them. All of this was captured on video, as were the later press conferences, which means, Your Honors, that the crimes charged in this case were committed on video. You will be able to watch with your own eyes the two accused committing the crimes charged in this case. We will start with some images of the first press conference from item 12 on the SPO's exhibit list. We invite anyone in attendance to follow through the evidence channel, and I ask confirmation from the court officer that I can proceed now. Here you see, Your Honor, the two accused, along with the KLA War Veterans Association Secretary, Faton Klinaku, making available to the press. Does it work? No. I'll wait for the matter to be solved.
Thank you. There's been a pause because of a technical issue.
Yes?
You can proceed now, Ms. Billot.
Thank you, Your Honor. So this first screenshot is an excerpt from the first press conference from item 12 on the SPO exhibit list. And you can see the two accused, along with the KLA War Veterans Association Secretary, Faton Klinaku, making available to the press the confidential documents they received. In the second screenshot, you can see Hisni Guzzati holding up the documents for the media. This next image, taken from item 249 of the SPO exhibit list, shows Nazim Haradinaj paging through the documents as the media takes photos and videos. And what did the accused say to the media as they were distributing the documents and making them public? What they said showed that they knew what they were doing, they knew what they had, they knew that these documents pertained to a criminal investigation of this institution, and they knew that they were confidential. With their words, they made clear their purpose: to intimidate witnesses, to make them afraid, to retaliate against them, to undermine the work of this court. We'll consider these words closely because they are important. First, Nazim Haradinaj, with Hisni Guzzati at his side, told the media that the documents were confidential and top secret. And of course, they knew this. They went through the documents, they understood very well that they pertained to criminal investigations carried out by this institution, and they assessed the documents to be confidential. and their assessment was correct. You will hear, Your Honor's evidence during this trial about the confidential nature of these documents. Second, Mr. Haradinaj went on to say that they could have kept the documents secret, but they decided to make them public. The following excerpts are from the transcript of the first press conference, corresponding to item 11 on the Spo's exhibit list. Had we wanted, we would not have made this public at all. And I'm quoting. Mr. Haradinaj told the media in the course of the first press conference that he and his co-accused could have kept the documents confidential, but they chose to make them public. They made the decision. Third, Mr. Haradinaj told the assembled media what was in the documents. And I'm quoting again from the same transcript. Here are the names of all the witnesses who they say are under their protection, all of them. And he went on to say the following. How can one guarantee protection to the witnesses when everyone can read this today? These words of Mr. Haradinaj were aimed at witnesses who had provided evidence to the SITF or SPO, to make them feel unsafe, exposed, and unprotected. He urged those attending the press conference to look at the documents and to take them. He told the media that the documents contained all the secret data about the witnesses, including names and surnames of Albanians, Roma, and Serbs, that they contained the date when every person was interviewed and the interview location. And then he went further, revealing the names and occupations of particular persons who had cooperated with the SPO, even going so far as to reveal the location where some of these persons resided. Now let's see the accused in action, because as I said, everything they did was captured on video. The clip that will follow is from item 12 on the Spo exhibit list and shows how familiar the accused were with the confidential documents that they were making public, and how carefully they looked at the documents before sharing them. We'll be playing a few videos today with the original audio in the Albanian language and subtitles in the English language. There is no need for the English interpretation of the words spoken in Albania, which also helps avoiding overlapping of sounds. We invite the panel and those in attendance to follow through the evidentiary channel.
Këto shënime, këta emna, këta mbi emna, tash le ta dim se janë emna të lexuar dhe nuk po del tu diçka që është dikush i fsheh, se ka vendin sakt, thirrje sakt, deklaratën ku ka thonë rideklaratë tjetër.
Let me repeat what you just heard Nazim Haradinaj say in this excerpt. These names, these surnames, they must know now that they are known names and that no one is unknown, because the exact place, the exact summon, the statement when he has given it, the next statement when he has given it, are all shown here. Notice the detail in his description and the message he is sending to the witnesses. No one is unknown. They are exposed. And it did not stop with the first press conference. Afterwards, the accused made several televised appearances to ensure that the content of the documents would continue to be known so that they could make further threats against witnesses. In one such appearance, which aired hours after the press conference on 7 September 2020, Hisni Gucati made it clear that he had recognized several of the names of persons he saw in the documents he had made public earlier that day. I will show a brief excerpt from item 34 on the SPO's exhibit list.
Çka ka, nëse mund ta them kështu kushtimisht, çuditshme në këto dosje, çfarë ke pa deri tash?
Po kam bo çuditshme ku i shot shumë gjë që na kemi besuar ta. Qytetarë tjerë që kam fjallën, që kemi besu, i kemi mojtë në për rota, në për të bime, i kemi respektuar sene.
I saw there lots of people in whom we trusted. The threatening message contained in these words appears even more clear, considering that on the same occasion, Hisni Gucati labeled those identifying as having cooperated with the specialist chambers as traitor of our country who lie. In the course of the same interview, Hisni Gucati stood by his decision to make the document public. Asked whether it was a good idea for him to have published the documents, Gucati stated that it believed it was a good decision and that this decision was discussed with the committee and other people. When the interviewer noted that things could happen because the documents contain names, Gucati acknowledged that things could happen. The following day, on the 8th of September, pursuant to an order issued by the court, the SPO seized part of the documents that the accused still had in their possession. As you can see from item 340 on the SPO exhibit list, the order instructed Hisni Gucati, the KLA War Veterans Association, and any other individual in possession of the documents and or their content to refrain from copying and further disseminating them and their content. But the evidence will show that this order did not stop the accused. They continued to urge dissemination of the material, and they solicited the delivery of even more confidential documents to the KLA War Veteran Association, so that they could make those public as well. On your screen is now item 420 from the SPO's exhibit list. It's a post from Nasim Haradinaj's Facebook account dated 8 September 2020. Beneath his own post with video footage of the delivery of confidential documents to the KLA War Veteran Association the day before, Nasim Haradinaj commented, "They can no longer make them disappear." He also noted that 3 more copies had been distributed, that those copies had been distributed to another 10 places, and that it is the task of these 10 places to further distribute another 3 copies each. He's acknowledging and encouraging the continued dissemination of the confidential documents. Meanwhile, the accused continued to make further televised appearances. The following video excerpt from item 110 on the SPO exhibit list is from one such appearances of Nasim Haradinaj on the 11th of September 2020.
Mirë pa janë cila është e vërteta, pe thojmë tashe, pe thojmë të nëherë. Sa herët na vjen si materiali, ne do ta bëjmë publik.
Whenever we receive any such material, we'll make it public. Far from being deterred, Mr. Haradinaj wants to go further, to get more documents, to continue to commit acts of obstruction of justice and witness intimidation, to undermine the work of this court. And in fact, it would not be long before Nasim Haradinaj's plea for more confidential documents would be answered. In the early afternoon of 16 of September 2020, an unidentified person again entered the premises of the KLA War Veterans Association in Pristina, this time carrying multiple boxes and folders, which he left on the floor before leaving. And what did the accused do? Exactly as they had the first time. Despite the judicial order they received the first time, they quickly held another press conference to share this new set of documents. Hisni Gucati and Nasim Haradinaj used the occasion of this second press conference to once again urge those in attendance to take the documents. They stated and showed on video that there are 3 copies available for the press, of several hundred pages each. Once again, they revealed confidential information, including names of persons who had cooperated with the specialist chambers and location of interest to SITF and SPO investigation. And once again, Nasim Haradinaj repeated his promise to make documents public whenever the KLA War Veterans Association received them. He noted that it was his duty and the KLA War Veterans Association duty to discredit the specialist court, and that this was the reason why the KLA War Veterans Association was disseminating the documents. The following day, on the 17th of September 2020, again pursuant to an order from the court, the SPO seized the documents that the accused still had in their possession. Once again, the order instructed all those in possession of the documents to cease any dissemination of them or their contents. The documents seized on this occasion, significantly less than the number of pages that the accused made available to the press, primarily consist of publicly available material. However, 6 pages are identical to those seized on 8 September 2020, including references to witnesses and potential witnesses and dates of births and professional functions of these persons. The mere words spoken by the accused at this second press conference once again substantiated threat to witnesses, a threat that was reiterated and reinforced. As you can see from the document on your screen, from item 5 on the Spo Exhibit List, Hisni Gucati signed the document acknowledging this seizure. As they did following the first press conference, the accused made a number of televised appearances after the 16th of September. We will listen now to Nasim Haradinaj at one of such appearances on the same day as the second press conference. He openly acknowledges his desire to damage the judicial process and obstruct justice through his actions. Here is the first clip from item 100 on the SPO's exhibit list.
A jeni të vetëdijshëm, zotë Haradinaj.
Po shumë i vetëdijshëm, Maria,
jo,
ka vodi.
se përfundova pyetjen për çka. A jeni të vetëdijshëm, zotë Haradinaj, që krejt kjo çfarë po ndodh, mund ta dëmtoj në fakt procesin e gjykimit të mundshëm.
Po çefi jam, po që kjo çefi jam.
Do të shkojnë në disa orë të njerëzve
që do të gjykohen.
Asked whether he was aware that all that was happening could in fact damage the court process, Mr. Haradinaj answered that this is what he likes. And he continued as shown in the next excerpt from the same video.
Mund t'i dëmtoj veteranët, s'po përmend emra. Jo, sepse mund thuhet që është penguar drejtësia pra.
Që drejtësi?
Po drejtësia
e tyre. Për aparatit Miloševićit, ka i tjetër kom i pegu. Atë
damage the court process. That is what Mr. Haradinaj wanted. And as for obstruction of justice, when it comes to this court, he will do that for all his life. Now let's listen to Mr. Gucati on the 17th of September. This excerpt from item 19 on the Spo's exhibit list is but one example of many public statements of this nature made by the accused in these days, all of which have been submitted to your honors to review and consider. Notice what Mr. Gucati says about what he has been ordered by the court and how he will nonetheless defy that order. Here are Mr. Gucati's words.
Jo, rad, ata mund thanë rad, që s'është mirë të dokumentacionet të shumëzohen, të shpërndohen, apo të publikohen emrat e dëshmëtorëve, si tha dhe advokati. Ne ju thamë se nuk jemi të interesuar me shumëzu, s'jemi të interesuar me fare, ne jemi të interesuar me demasku këtë gjykatë speciale, me ju tregu juve çdo material që na vjen neve këtu, ne do t'ju tregojmë juve se ne jemi kundër gjykatës speciale. Ne kemi thënë me kohë se kjo gjykatë është raciste, është e njanshme, për ne është e papranueshme dhe kjo është arsyeja pse ne publikojmë gjithë këto dokumentacione. Aja ka qenë, ata të unë më kanë detyruar edhe më ftesur, kështu që shkruan, që më thotë që vetëm shumëzimi i tyre s'bën tjetër, edhe shpërndami aty në thotë nuk bën.
They told me clearly that these documents cannot be multiplied, distributed, or the names of witnesses be published. Mr. Gucati understood that he had been ordered not to disseminate the documents, but he would not stop. As I said at the beginning of this opening statement, he was so determined to undermine the work of this court that he was willing to defy a judicial order, willing to break the law, to intimidate witnesses, and as such obstruct the work of this court. And it continued. The following excerpt from item 31 on the Spo's exhibit list is an appearance by Nasim Haradinaj a few days later, on 20th September 2020. Listen to the word he used to threaten witnesses and what he says about his intent in making public the documents.
Këto dosje përbojnë dy të mira që përdalin. E para, pe demaskojnë gjykatën dhe pe tregojnë që këta ngritën mbi të dhënat e kriminalëve, gjakpirësve.
He refers to those who provided information in relation to investigations of this court as criminals and bloodsuckers. And then he goes on by saying the following.
Rani parë keme ka du vetëm kështu. O qishona, o bëdoll, o të shpiuna të lenë, shpiuna. Bësh mendoni që ju mbrojnë kush veç sa të shfrytëzon se kurr në botë nuk mohet man që e ka mbrojt dikush shpiunin mbas e ka shfrytëzu. Përkundazi, o ka vra, o ka diskreditu, o ka bokare. Dhe tash, të pritish ti të tratosh popullin ton, ushtrin tonë, të rrajsh të shpifës, me fakte të armikut.
He refers to witnesses as fools or spies, and says that no one has ever protected a spy. On the contrary, spies have been either killed, discredited, or derided. Again, Mr. Haradinaj continues, this time making his intent very clear.
O, ka më rëzu krejt. O, ka më rëzu krejt, shka lexova në botë cilat dëshmi o bo, ka më rëzu krejt. Sepse tash edhe dëshmitarë që bedin që bëdijen.
Referring to this court, he said that the court will totally collapse because the witnesses too know now that others know who they are. And finally, from the same video.
Pra kënë vullnet dëshirë të mënu që të vërteta, për momentet që i kanë verifiku, thamë jemi shumë të lumtur dhe janë të mirë sa ardhur, sa herë kanë kësishe.
Sa herë ka ardhur persona, sa herë kanë pru dokumentacion? 2 herë, po më duket i tash është
E mirë është që kanë ardhur 2 herë, po ma mirë është që kanë premtuar se vinë apel.
With these words, Mr. Haradinaj openly explains that his aim is to scare and intimidate witnesses in order to bring down the court. Despite 2 court orders, he continues to seek more confidential documents so that he can disclose those as well. Meanwhile, the accused continued to post about the confidential documents on social media. Item 120 from the Spo Exhibit List that is now on screen is a 21st September 2020 post published on Hisni Guzzati's Facebook account, in which he states that the files handed over to the KLA or Veterans Association were official documents of the special court, which included the names of the majority of witnesses. He refers to the documents emerging from the special court offices as very confidential and sensitive. Hisni Guzzati states that the files include statements made by witnesses against the KLA, and that the people who chose to hand the files over to the KLA War Veteran Association meant to burden it with a great responsibility. As Mr. Patch will show you in the next part of this opening statement, the accused commission of crimes did not stop after these first 2 press conferences of 7 and 16 of September. Did not stop with the accused making several televised appearances and uploading multiple posts to social media between the 7th and 21st September. Rather, they continued their pattern of criminal conduct until the day of their arrest. I will leave now the floor to Mr. Patch.
Good afternoon, Your Honors.
Mr. Potts.
Just in terms of timing, I'd like to let you know that I understand this session will go up to about 1 o'clock, and I hope to be done with my presentation and the entire opening by that time. As my colleague indicated, I will continue taking you through the key events underlying the charges in the indictment. Specifically, the events that occurred from 22nd September onwards. At around 10:30 in the morning on 22nd September, an unidentified individual again walked into the KLA War Veterans Association premises and delivered another set of documents. Once again, the accused took no steps to alert authorities about these documents, but instead, they acted quickly to make them public. In fact, less than 2 hours after the delivery, Hisni Guzzati and Nassim Haradinaj held a 3rd press conference, during which they invited those in attendance to look at and read the documents, take copies of them, and publicize their contents. The image before you, from item 160 on the exhibit list, will look familiar. It's a similar setup as that in previous press conferences. In this particular image, you can see Hisni Guzzati, Nassim Haradinaj, and Fatan Klinaku with the documents they are making public in front of them. As Hisni Guzzati himself stated at the beginning of this 3rd press conference, and I quote, "It seems it has become a routine. We have made you, the journalists, a little tired by inviting you." End quote. Indeed, it had become a routine of breaking the law, of committing crimes to intimidate witnesses and obstruct this court. Before giving the floor to his deputy, Hisni Gucati noted that the documents contained the names of many people. He reinforced the message repeatedly sent to the general public over the previous 2 weeks. The accused are making public the names of those who cooperated in SPO investigations. Mr. Gucati then stated as follows: "We will disclose them to Kosovo people, to our country, to everybody. We will show the truth that these here tried and are trying to discredit the KLA by all means, but they will never succeed." In this excerpt from item 159 on the exhibit list, Mr. Gucati gives away his purpose in making public the names of the witnesses, to expose them as enemies and to ensure that this institution does not succeed. When Nasim Haradinaj took the floor, following his co-accused and in his presence, he delivered similar information in even greater detail. He also sent out the same intimidating message. Mr. Haradinaj made clear that he was fully aware of the nature of the documents that the KLA War Veterans Association was making public. He noted that the documents in front of him bear the SPO logo, and that he understood that they concerned a draft indictment in relation to 5 suspects. He named the 5 suspects one by one and provided the names of several locations referred to in this document. None of the information relating to these alleged crime locations was public at the time. And the accused knew that the documents were confidential, because they were clearly marked as such, as we'll see a little later. Mr. Haradinaj underlined that there were details of many people mentioned in the files, just as his co-accused had done a little earlier. Mr. Haradinaj said one of these names out loud, and said that there were the names of many, many other people. He then invited the journalists in attendance to read the documents themselves, thanked them for being active, and urged them to do their job and divulge the information he was making available to them. Mr. Gucati further emphasized that the documents were for the media to take, stating, and I quote, "You have the document in front of you. We gave it to you," end quote. He also asserted that 80% of the people who gave the evidence set out in the document were Albanian. This shows, Your Honors, that the very moment the accused provided the media with this third set of confidential documents, they were fully aware that they were in fact disseminating names of individuals who provided evidence to the SPO. Several exchanges in this third press conference demonstrate not only that the accused's intentions were willful, but also that the accused were determined to commit actions they knew were criminally sanctioned. I will show you 2 brief excerpts from item 160 on the exhibit list. Here is the first video.
Ato që mundi, shka mundi.
Kjo është ndalume,
Nuk e di.
është dënuar deri në 10 vjet burg.
Unë nuk e di.
Jo, kështu është ligji, këtë ligji që ka special.
Të shka këna unë në burg, të tute.
And this is the second excerpt from the same video.
Shtinin media, ti e shaku të zej. Ta shti e kam tut me 10 vjet. 300 vjet me hapshin për që punën e ses. Unë, që më ka voli unë. Edhe na kërësia komplet. Ne jemi të përgatitur, 300 vjet. Ne jemi konë përgatitur me dek. Ti jaroni jam një ki qoshet, ka të vytë, ty ka të vjenë ma flatë. Ama më shëptoj si ti. Qa kom të punë me ty? Ti e media, unë e di një punë. Thash mu e ma ishti, je forca 4 e shtetit.
We are ready to face 300 years. The words of the accused could not be any more clear. They knew they were breaking the law, but they were willing to go to prison in order to obstruct the work of the court. As outlined by my colleague earlier, the accused had by now been reminded several times that the dissemination of confidential documents pertaining to SPO investigations was illegal. The accused themselves confirmed the warnings that they had previously received. For example, during this third press conference, when they were asked whether they had been told by the SPO not to disseminate the second set of documents, Mr. Haradinaj gave the response you will hear in the video I will play next.
Jo, valla të përshef, s'ka që bëjmë lajmërues, bila ta na ka thonë me autorizuar ty në, po na kem kallëzu se na nuk bashkëpunojmë me ta. Po na ka thonë, po na nuk e kem ngu, ose ka i gojma se kam plan me ngu. Ata që kanë plan me ngu, goni. Edhe ju ndashëm me ngu, se i keni ngu edhe media, se i keni dosit. Prandaj mos boj kishë se keni. I keni marrë çdo.
They asked us to hand them over to them, but we told them we will not cooperate with them. Yes, they did tell us, but we did not listen to them. We are not listening to them, and we do not intend to listen to them. That's what you just heard Mr. Haradinaj say in this excerpt from item 160 on the exhibit list. As Hisni Gucati had earlier on during this press conference, Nasim Haradinaj also spelled out his and his co-accused reasons for continuing to violate the secrecy of proceedings, for publicly intimidating SPO potential witnesses. He stated, and I quote, "We will publish everything that we receive here. We won't keep anything secret. We will publish everything we receive that exposes this indictment and these indictments they want to file." End quote. The last part of this televised press conference from the same video clearly shows how the documents in the accused's possession were accessed by those in attendance. We'll take a look at the video now.
Nëse s'ka dikush që s'ka kështu përfundu. Jo, për rrimna, aja lojmë të një kopje të mojnë, pra ta i kopje le aty. Një kopje të përshuje të apo. Një kopje që njëtë. Ha? Po, hadi, me në te po me të kryetarë, unë e përkik të kryetarë i pitë të bosh. Dhe me mund e pitë të bosh kryetarë. A në vishë përse një kopje të ndërsu? Jo, më marë për këta, mja u dhonë qep nuk ta marrin, e ka shre. Mund do të me inqizue se për shamën të qipë dhe ati gazetore, thotë se o kini dhonë gazetore.
Within hours of the 22nd September press conference, the SPO served an order instructing Hisni Gucati and/or the KLA War Veterans Association to produce all SPO documents. Nasim Haradinaj signed a document acknowledging receipt of this order, and the documents were handed over to the SPO. The page on your screens now is an excerpt from the document seized from the KLA War Veterans Association that day. As your honors can see from this and other pages available to you, the document contains clear markings with the words confidential at the top and bottom of the pages, the words internal work product, as well as the SPO logo. The actions of the accused did not end with the press conference and the handover of documents. Just as they had done before, the accused went on to make a number of televised appearances. Each of these appearances contains highly probative evidence regarding the actions and intent of the accused. I will direct your attention to just a few of the many statements made by the accused in these televised appearances. During one such appearance on 22nd September, Mr. Haradinaj confirmed that he and his co-accused had distributed materials from the third set of documents to the press earlier that morning. He then stated the following, as you'll see from the next video.
Spo kuptoj këtë krahasim që po më. Unë po ju pyes, nëse ju po arkivoni këto dosje në arkimin tuaj?
Jo, sepse i arkivu t'ju, pse me arkivu na? Ne jau kem qitë, jau kem dërzu, ju keni arkivu sa keni dashtë. Ka qenë merë të gjithë, merë sa dush, le sa dush.
Jo, është pak e çuditshme në qoftë se të gjitha i dorëzoni dhe asgjë nuk ruani për vete për një proces tashëm.
Po ne nuk po na vjen sa se ne jemi organizatë jo qeveritare, është dëm për ju nëse s'keni marrë sa dasht. Dhe do të më armë.
We gave them to you. You have archived them however much you wanted. There, Mr. Haradinaj entirely acknowledges providing the documents to the press. Moreover, he said the press should feel ashamed if it did not take as many documents as it wanted from the KLA War Veterans Association. That was from item 145. At multiple televised appearances after the third press conference, Hisni Gucati again made it clear that his goal, and that of the KLA War Veterans Association, was to obstruct this court, and that they had every intention to continue doing so and to continue publishing the materials delivered to them. I hope this court is abolished as soon as possible, and they stop all their activities against members of the Kosovo Liberation Army. There is no doubt about Mr. Gucati's intent in these words from an appearance which also aired on the 22nd of September, and that's item 141. In the following video clip, from a different show which also aired that day, you'll hear Mr. Gucati stick to the same message. Let's take a look at the video.
Po mu s'm intereson kush ka bu, kush I ka nxjerrë. Mu më intereson që më kanë ardhur në zyre, edhe jam jashtë me çdo formë me demantu gjykatën speciale dhe
My responsibility is to undermine the special court. Here is another video from the same show.
Vetëm lejo këtë, kur ndodh që të shkojnë pastaj ushtarët UÇK-s, komandantë e tjerë, të hetohen dhe të gjykohen nga kjo gjykat, pastaj do të mund të përdoret kjo që po e bëni ju kundër tyre, që Kosova ka tentuar ta minojë administrimin e drejtësisë.
Unë nuk besoj se kjo mund të jetë bumerang për neve apo për pjesëtarët tonë të ushtrimit të Ne jemi shumë të imozhën në kësaj gjykate shtajmë për tokë. Çdo dokument që vjen unë pe gjykatë speciale bie dikush para derë madje ne të bëjmë publik për hir të opinionit dhe për hir të shokëve tonë që tregoj një realitet që është ka ndodhur edhe është duke ndodhur ende. Kjo është ne. Ne mund të gjykatë speciale për 5 minuta e jekum krejt. Shpërbëjmë këtë gjykatë speciale.
In this excerpt, you heard Hisni Gucati once again clearly stating his intentions. We will disband the special court. In the next clip, the last from the same show, you'll hear Mr. Gucati echoing his co-accused in his willingness to go to prison for his actions.
Pra edhe nëse mund të ketë ndonjë pasojë penale për këtë, ju nuk jeni pishman themi që po I publikoni këtë.
Unë as 1 milimetër, unë edhe 5 vjet për më jep, unë jam I gatshëm të përgjigjem gjykatës speciale për publikimin e dosjeve.
Even if they were to give me 5 years in prison, I would be more than ready to answer the call of the special court about the publicizing of the files. That's what you heard in this last of 3 clips from item 139. The last video footage I will show you today is from item 81. And this is a video of a televised appearance featuring Nasim Haradinaj on the 25th of September, shortly before his arrest. In these clips, Mr. Haradinaj shows that his determination had by no means diminished at this stage.
Një rrjedhë është sigurt. Sot ta moni man. Sot të jetojmë të jemi frymë. Ne jem kundër kësaj gjykate. Fund. Kemë punu kundër kësaj gjykate. Fund.
And to the next clip.
Ne na I ka prit. Ai që ne ka sholla ta. Sholla na bjen apet. Nuk do të thonë me unë zoti Gucati se vetëm klinaku që do të bëj. Edhe amtori më I mbrëmi UÇK se do të jetë këtu kamë këtë detyrë. Kemë që mediat dhe të fillin.
We will work against this court. God willing, he will bring us more. We will disclose them to the media. That's what you heard Nasim Haradinaj say in this interview moments before his arrest. That was how determined he and his co-accused were. So determined they were willing to break the law. This pattern of criminal conduct by both accused, which started on the 7th of September 2020, only came to an end on the 25th of September, when they were arrested and subsequently taken into custody of the specialist chambers. The evidence will show that the effects of their criminal conduct outlasted their arrests. The seriousness of the threats made by the accused against witnesses and potential witnesses cooperating with the SPO emerges through the video evidence in this case, some of which has been highlighted today. In particular, the evidence will show the accused affirming publicly and repeatedly that information pertaining to confidential investigations will be used to undermine the work of the court. The evidence will show the accused exposing witnesses, potential witnesses, and persons who cooperated with the investigative authorities, describing them as traitors and spies, stating that no witness can any longer be protected. These assertions are in themselves very serious threats. The evidence will also show the accused indiscriminately distributing documents, including personal data of individuals who cooperated in SITF and SPO investigations. This adds an additional level of intensity to the harmful actions carried out by the accused. To conclude, as you heard today, this trial is about the specific actions undertaken by the accused, who resorted to clearly criminal behavior to achieve their objectives, leading them to commit the crimes for which they are charged here today. The evidence will show that the accused committed the crimes charged in the indictment repeatedly, knowingly, intentionally, and enthusiastically. After the evidence is presented, we will ask that the accused be held responsible for their actions. Thank you, Your Honours.
Thank you. This concludes the opening statement of the Specialist Prosecutor and the end of today's public hearing. We will resume on October 18 at 9:30 in the morning to hear the testimony of the first SPO witness. I thank the parties and the registry for their attendance. I also wish to thank the interpreters, stenographers, and audio-visual technicians and security personnel for their assistance. This hearing is adjourned.
Hmm?